Hearing, hearing. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Please be seated. Welcome to another virtual convocation of the First Court of Appeals. We have one case on today's docket, 01-20-00419-CV, Albert G. Hill III versus Margaret Kelleher et al. And can we have the appearance of counsel on behalf of the appellants, please?
Aaron Cooper representing Al Hill III.
And for the appellees?
Tom Dees with Hallett and Perrin for the appellees, Your Honor.
Good afternoon, Your Honor. Brian Mason on behalf of the appellees as well.
And you're both representing all of the appellees together?
That is correct.
Okay. And you have indicated that Mr. Cooper would like 11 minutes for primary argument. Mr. Dees and Mason will split their 15 minutes, 5 minutes to Mr. Dees, 10 minutes to Mr. Mason, and then Mr. Cooper will return for 4 minutes of rebuttal.
Yes, Your Honor.
Yes, Your Honor.
Right. Well, after the appellees counsel is taken from the screen, Mr. Cooper may begin.
May it please the court. There's no doubt that my client is the victim of a conspiracy to have him indicted, and he was indeed indicted. There have been numerous court cases already over these issues, and numerous facts presented to those courts and to the lower court in this case, showing that undue pressure was put on the DA, Mr. Watkins, and that through the pressure of bribery, pressure on the office, and through the submission of false statements, my client ended up being indicted. And the Fifth Court of Appeals in Dallas said that my client was indicted specifically because Watkins was under the influence of Al Hill Jr., my client's father. We're here today, though, because the trial court failed to follow the Tcpa guidelines and the spirit of the Tcpa, which is designed to provide, a quick remedy for defendants who feel like their constitutional rights are being violated. And because of it's supposed to be a quick remedy, there's specific deadlines in place: 60 days for filing a Tcpa motion to dismiss after they've been served with the petition, and then 60 days to have the hearing after they've filed their motion to dismiss. They did not meet either of those deadlines. I want to focus first on the hearing deadline because I think that's the clearest one. They did not meet that deadline.
Well, hadn't the case been removed?
Yes, sir, Your Honor. The removal kind of deals with the filing of the motion to dismiss. So we still believe that there's a difference between a statutory deadline and a judicial deadline, as was dealt with in Hearst Newspapers versus Stats Lounge, where the 14th District Court in Houston talked about how the Defense Mitigation Act told the timeline for the TCPA because the TCPA was a statutory deadline, and because the DMA, the legislature for that specifically, addressed statutory deadlines as well. But we don't believe that the removal automatically would toll a statutory deadline, especially when you're talking about strategic choice.
What action could the state court take if it didn't have jurisdiction? Because removal removes jurisdiction from the state court to the federal court. And correct. If the court can't take any actions, how can it even receive a document for filing?
Well, they made a strategic choice to move it to federal court when they could have filed in state court, stayed there and filed their TCPA motion.
But where are they given? They move it to federal court, and we have a supremacy clause, and so the federal court gets jurisdiction. What action could the state court take?
I don't know the state court could take any action.
And so how could they even receive a document for filing if the court can't take any action?
They could not have.
Okay. The record in this case is voluminous. We have approximately 2,000 pages of it, but there's references to a trial court record of over 4,000 pages. And not that you necessarily want them all, but where are the other 2,000 pages and what's in them, and why don't we have them?
I'm not sure, Your Honor. We pulled the main motions and what we thought was the relevant evidence to those motions into the record, and then appellees did the same, pulling in what they thought was relevant to the record.
In particular,
Question. Oh,
I just want to follow up on one question, Richard.
okay.
In particular, there are two exhibits, C55 and C56. They were attached to Mr. Hill III's original declaration. The appellees specifically carved those documents out from evidentiary objections. So they were one of the few documents that were admitted without objection. What are those documents, and are they before the court now?
I would say they are before the court now, but I do not know what they are off the top of my head, Your Honor.
I have a question I'd like to ask. As to your allegations just against the Tatham, Donnelly, and Waller defendants, I'm a little unclear as to how you're tying them into your malicious prosecution claim. Did they participate in making a report? Did they communicate or associate with the other defendants in making a report? How are they involved in this? How do you tie them into your malicious prosecution claim?
I don't believe we have any specific evidence on their activities involved in the malicious prosecution claim, but I think that there's enough reasonable inferences that our client has made through his declaration that would lead us to have the right to proceed and get discovery on that.
So
yeah.
go ahead, Peter.
Your allegations against those three, Tatham, Waller, and Donnelly, is that for conduct pertaining to the pertaining to the prosecution, the initiation, procurement, and continuation of the prosecution of Hill III?
Again, Your Honor, I don't know what specific actions they took. My client believes that they were involved in the conspiracy, and in whatever way they may have been involved in the conspiracy, they would be liable for the acts of all the other conspirators.
So their actions pertained to the ultimate procurement of the prosecution.
We believe so, Your Honor.
Thank you.
I guess my main focus real quick should be that, so I'm looking at my time, I think the hearing deadline was clearly missed. After they filed their motions to dismiss, they had 60 days to have the hearing deadline, to have the hearing on the motion to dismiss. They originally had a setting within that 60 days, except that one group of appellees did not have their motion to dismiss set yet. When they tried to set it on the same day as the others, they were told there was no time to have that done. Then it was rescheduled for outside of the 60-day period, and everybody agreed to that. There was no attempt to contact the court and say, wait, that's outside the 60-day deadline. They made no diligent effort to try and get it back within the 60-day deadline. And to receive the benefit of the extension, there has to be docketing issues that are preventing it from happening, but there also has to be evidence in the record that appellees made the effort to get it back within the 60 days, that they informed the court that we're outside of the 60-day deadline and we're going to lose the protections of the TCPA unless we have the hearing on time. They didn't do that.
What is your best case for that proposition?
For the 60 days.
I mean, with regard to the effort that the movement has to go through to secure the hearing. 60 days is in the statute, but are there any case situations that have arisen in the case law where it's like this?
There are. I'm looking for them and I'm not seeing them right now in my notes, but I can provide that immediately after.
Okay.
The other issue I wanted to raise quickly was just on review of the evidence. I know there's a voluminous amount of evidence out there, and all of it was objected to, and that objection was sustained with one sentence. Made the majority of the basis for their objections was relevance, hearsay, and best evidence, things which really shouldn't. Obviously, relevance could be a consideration. Best evidence and hearsay are not considerations in a TCPA action, and or they're not a basis for excluding evidence. And with the cases I sent in yesterday to the court, especially Baylor, Scott, and White, it talks about that a de novo review puts the ruling of a TCPA, the de novo review of a motion to dismiss ruling on TCPA gives the reviewing court the right to review all of the evidence itself too, not to rely on the trial courts or to defer to the trial court. It actually involves a de novo review of the evidence. So I don't think that my client's arguments before this court are limited to evidence that wasn't stricken. I think that even evidence that was stricken could still be reviewed by the court.
Mr. Cooper, I have a question about that, but well, it's kind of twofold, because the briefing on that doesn't really get into the specific evidence and your specific arguments for what should be coming in and why in response to what happened to the trial in the trial court. Are those types of is that type of information available in the trial court record somewhere? It just seems like there's so much evidence. And while I know your argument is, that their objections maybe were too global, I think we also need the benefit of understanding what your arguments in response are, like in a detailed way. We can't just comb through all of it and figure it out.
Sure. I think the easiest thing to say would be that its declaration, we believe, should be considered in its entirety, and the exhibits to that as well, unless this court finds a reason that they should not be admitted as evidence. So I think the declaration does pinpoint several specific pieces of evidence. And I think that his declaration also provides factual assertions and not just conclusory material. Also, there are some things that are still in the record that were never stricken, including documents relating to the transaction itself at CR 4077, 4079, 4072, 4074. These are things where it's talking about the parties will keep this contract confidential. There won't be, the contract wouldn't be filed in property records. The deed wouldn't be submitted to the county, which it wasn't for 5 years. And most importantly, at 4077, an option agreement, which was a 40-year continuing exclusive and irrevocable option to repurchase the Bordeaux property, which all of that combined basically sustains my client's assertions that it was never intended to be a true sale. It was papered that way, but it was basically an advance on his inheritance, just as he's described in his declaration and his amended petitions.
Any other
And if
questions?
the court wants more specific evidence, I'd be happy to prepare a chart. We did that as well for the Fifth Court of Appeals when they asked for what prima facie evidence was in the record, and it would be a short chart.
Are there any other questions from the panel? Thank you, Mr. Cooper.
Thanks, sir.
Mr. Mason? I'm sorry, Mr. Dees.
Thank you, Your Honor. May it please the court, my name is Tom Dees for the appellees. I'll be addressing the issue of timeliness of the appellees' 4 motions, and my colleague, Mr. Mason, will be addressing core TCPA issues. From the outset, we believe the trial court got it right, that the motions were filed timely, that the hearing was conducted timely, that the order granting the motion was entered timely, and we're asking this court to please affirm the trial court's ruling. As Justice Kelly noted, this case was removed when it was in the trial court. It's somewhat unusual. So the question became, what was the effect on the state court TCPA deadlines? Interesting to note that during the removal period was the period when the Fifth Circuit issued its Clock versus Watson opinion addressing the applicability of the TCPA in federal court. But the appellee's position, and this was a big issue for the trial court, he pushed us on this. He wanted to know, he was very curious. What happens to the deadlines? Our position was that they were suspended upon removal because the state court had lost jurisdiction, and then upon remand, they were immediately reinstituted. We briefed this in the clerk's record 4415 through 4472. In fact, the trial court was satisfied because he found specifically in his order granting the TCPA motions that all of the motions were filed timely. That's clerk's records 4577. With respect to the hearing on the TCPA motion, as you know, 27.004 requires the hearing to occur within 60 days unless the docket conditions of the court require a later hearing or showing of good cause, but in no event longer than 90 days after service of the motions. That's what happened in this case. On December the 11th, the trial court conducted a hearing on all 4 TCPA motions. It was after 60 days beyond service of the motion, but well within 90 days. It was right in the sweet spot, consistent with the statute. So the trial court got it right here. And importantly, the appellant has cited no case, none, in which the trial court granted a TCPA motion to dismiss where the hearing occurred after 60 days, but well within 90 days of service of the motion. And then the Court of Appeals came along and said, nope, we've got to reverse that because the hearing occurred after 60 days. I kind of feel like the lady from the old Wendy's commercial. Where's the beef? Where's the case that says this court should reverse the trial court? When we look at all the cases that the appellant cited, Morin versus Law Office of Kleins Gruber, Braun versus Gordon, Braun versus Haley, Grubbs versus ATW Investment, Whitman Cervantes versus Hernandez, N. Ray Herbert, not one of those cases had a hearing that was held within 90 days of the service of the motion.
How do you specifically address the appellant's argument that you essentially made an election, you forfeited your right to pursue a TCPA dismissal by basically squirreling the deadlines, by removing the ability of the trial court to act, by removing it to federal court? It seems like you're having your cake and eating it too by removing it and reinstating the deadlines.
But two ways. One, the appellant relies on the Kinder Morgan opinion, the 2019 opinion for the decision that the appellant's strategic decision to remove the case doesn't warrant an extension of the deadlines. That case was reversed on April 30th of 2021 by the Texas Supreme Court, finding the motion, the TCPA motion, that motion was timely filed. More importantly, though, just kind of big picture, the TCPA does not say anything about you have to make an election in state court, and were a movement to remove to federal court, they somehow lose the ability to come back and utilize the state statute. And frankly, it's inconsistent with what happens with removal. As you were describing, the state court lost jurisdiction, was divested of jurisdiction upon removal, and no further action could be taken in the state court.
But the relevant statute, but chapter 27 is silent on the effects of removal one way or the other.
Yes, Your Honor, but we believe that the Eastland Court of Appeals answered the question just recently in the cases that we submitted with a letter brief just recently, the Ruff versus Ruff and Clayton Mountain Development versus Ruff, where the Eastland Court of Appeals specifically found that the removal suspends state court deadlines with respect to the TCPA, and they're reinstated upon remand. With respect to the hearing, we believe it was timely. We believe that the trial court, that there was no reason that the trial court could not have conducted the hearing on December the 11th when it did, because it was within the 90 days, consistent with the statute. There's ample evidence in the record that the appellees were diligent in setting their hearing. For example, supplemental clerk's record 4, 5, and 6, supplemental clerk's record 115, 117 through 118. I see that I'm out of time, but if you have questions, I'm happy to entertain them.
Any questions from the panel? All right, thank you very much.
Thank you very much.
Good afternoon, Your Honors. May it please the court. Your Honors, this court should affirm the trial court's decision to dismiss these claims based on the TCPA for 3 reasons. Number one, the claims that were asserted by the appellant in this case are based on, relate to, or in response to the appellee's First Amendment rights. Number two, the appellant has failed to bring forth clear and specific evidence of each essential element of his claims against the appellees here. And number three, and although we don't believe that we should ever get to number three, to the extent that we get to the affirmative defenses, the appellees here have satisfied their burden by a preponderance of the evidence to establish that the appellant's claims fail as a matter of law based on release and other affirmative defenses that we'll talk about here in a few minutes. With respect to step one in the TCPA analysis, we have three causes of action at issue here. We have malicious prosecution, we have conspiracy, and we have aiding and abetting. In our briefing, we cited a number of courts that have looked specifically at causes of action and allegations relating to malicious prosecution, where the courts have found that
Mr. Mason, I'd just like to follow up on a couple of things. One is, do you know what exhibits C55 and C56 are and whether they are before the court?
Your Honor, I do. Exhibit C55 is the general warranty deed relating to the underlying Bordeaux transaction in 2004. I believe that C55 is in the record as attached to the appellant's evidence. However, to the extent it's not, I do know that it's part of the record. It's clerk's record. It's in there a few times, but 866. With respect to C56, that is the notice of agreement, again, relating to the underlying transaction. I don't have that specific clerk's record citation. I'm happy to provide it immediately after the hearing, but again, that one as well, I'm virtually certain that that is part of the part of the record.
Thank you for just identifying what the documents are. Appellant intimated that we're engaged in a de novo review up here. What is our standard of review of the evidentiary objections?
Well, I believe that the appellant here still had an obligation to specifically identify the points of error that the trial court made with respect to these evidentiary objections. I mean, the position of the appellant here is essentially, appellate court here, let me give you our 6,000 page record. You guys go look at it and figure out, whether all these objections were proper or not. And I don't believe that that's the law.
What is our standard of review on this? I mean, is it true that we have a de novo free hand on this, or traditionally evidentiary rulings are for abuse of discretion? Does the TCPA change that?
I don't believe that the TCPA changes that, but I believe it is a de novo review, but I believe that the specific issues have to be identified and preserved both at the trial court level and here in order for this court to specifically address them. We've heard a lot about, and the appellant has actually conceded that a lot of the objections that were made based on lack of personal knowledge or conclusory were proper, which is consistent with what the Texas Supreme Court has held in the Relipsky case. But there's been no attempt at all to differentiate and provide this court with any sort of indication. So I don't think that this court has any obligation to go through every single specific objection, which is essentially what the appellant is asking this court to do, and make a determination as to whether or not those objections were appropriate. And again, a majority of these objections, they have conceded that they were appropriate, and they've done nothing about all of the other ones. With respect to the applicability of the TCPA, we cited numerous cases relating to the malicious prosecution. This court, in two different cases, the Buckingham case, and then since our briefing has concluded in the Smith v. Hammonds case, has also looked at issues with respect to whether malicious prosecution claims are subject to the TCPA. One of the issues that the appellants raised with respect to the conspiracy claim is that conspiracy claims cannot be subject to the TCPA if there's some sort of underlying criminal activity that is alleged. But the cases that are relied on by the appellant here are not at all applicable. For example, in the gas camp case from this court, the court examined the underlying tort, which was relating to the misappropriation of trade secrets. If you look to the other cases that are cited by the appellant, all of these cases look to the underlying tort when determining whether the conspiracy allegations are in fact subject to the TCPA. And for those reasons, for all the reasons we've cited in our case law, in our briefing.
To that point, or I guess parallel point, corollary point. The allegations in the petition are a little bit broad and vague. Is there enough detail? Do they have to be alleged in detail in order to establish that there has been a specific violation of a constitutional right? Or do we just sort of look at the tenor of the entire complaint and what it's going towards?
Justice Kelly, I think the Supreme Court has made very clear in Henry Lipsky and other cases as well that there has to be clear and specific evidence that is put forward. They cannot be generalized allegations. Notice pleadings are insufficient. And here, that is exactly what we have. And with respect to the evidence, the clear and specific evidence or lack thereof.
I guess the problem though is if you have a broad allegation, but for instance, where is the allegation specifically that Ms. Waller specifically was pursuing a constitutional right?
In the sense of whether the appellant brought forth clear and specific evidence. I mean,
Well, made a clear allegation to bring it within the ambit of the TCPA.
Well, I think if you look at the allegations with respect to Ms. Waller, that are set forth in both the supplemental declaration and in the second amended petition, which is essentially a copy and paste, they talk about Ms. Waller being affiliated with Al Hill Jr. in the 2020 action, which is discussed throughout our briefing. They talk about Ms. Waller being affiliated and communicating with Al Hill Jr. with respect to trust. They tie all sorts of things back to the 2020 case. But with respect to Ms. Waller, as Justice Hightower pointed out earlier, there is absolutely not a single allegation in any way, shape, or form relating to these underlying facts and circumstances with respect to Ms. Waller, Mr. Donnelly, Ms. Tatham. And with respect to the other appellees here, with maybe the exception of Mr. Pickett, there is essentially a throwaway sentence at the end of all of these paragraphs in both the supplemental declaration, which was properly struck and should not be before the court, and that is also in the second amended petition that just generally states that Ms. Kelleher, Mr. Miller, my sisters provided information to the district attorney that was used as part of the prosecution, or they met with BB&T and information was used by the prosecutors. That does not rise to the level of the clear and specific evidence standard that the Supreme Court has made clear must be found here. There's no who, what, when, why. There is no who was talked to, when did this happen? And the appellant here had 3 opportunities. This is the second amended petition. He amended his petition again after we filed these TCPA motions. If he had,
did you ever make any special exceptions?
We did not make any special exceptions, Your Honor. But we filed our TCPA motions based upon the first amended petition. He came back and he submitted in his opposition a supplemental declaration. He filed his second amended petition. He had every opportunity in the world to put forth knowledge or alleged facts, and they're just not there. It does not, these are.
Sorry, I need to interrupt real fast though. I think I just need to, this might be repetitive, but Tatum, Waller, and Donnelly. If what you're saying, especially with those 3, is that the allegations essentially kind of barely show, anything, that they're just maybe tangentially involved, then how do they get to be protected by the TCPA?
They get to be protected by the TCPA because, again, the allegations, the cause of action alleged against them is a conspiracy to be involved in a malicious prosecution. And the cases that examine whether conspiracies is subject to TCPA look to the underlying alleged tort, which is here malicious prosecution, where numerous courts, including this one on numerous occasions, have found that the TCPA applies to malicious prosecution cases.
I mean, wouldn't we look to it as a whole, that they basically have taken the position that all of these different defendants in working parts have contributed to the malicious prosecution claim?
I think with respect to the first step, Justice Hightower, in terms of whether the TCPA applies, I think when you get especially to step 2 and whether there's clear and specific evidence, I think it's really important for your honors to isolate each of these appellees and see the lack of of evidence that has been brought forth by the appellant here. I see my time is up, but I'm happy to answer any other questions that your honors may have.
Any other questions from the panel?
I do have one. Going to your, we didn't get into any of your arguments in regard to the elements of the underlying claim. But in regard to the probable cause element of malicious prosecution, I mean, the plaintiffs are taking the position or contend that the appellees knew the Boudreaux property advance was not a true sale of the property, knew the Al Hill Trust was not defrauded. They knew the bank had not been defrauded. And then in fact, the bank didn't even file a complaint. Did these types of allegations establish that defendants lacked the probable cause to initiate the prosecution?
Respectfully, no, Justice Hightower. And if you go back and you look at the appellant has contended that everyone knew that this was in advance, but he puts that in a self-serving declaration that's submitted literally 7 or 8 years later. If you go back to 2010, when the Lens submission was submitted, when the alleged Pickett submission was submitted in April of 2010, which is what you need to do with respect to lack of probable cause. You examine that at the time, not necessarily what has happened after the fact. But if you look at these underlying transactional documents, the real estate contract is clerk's record 855, the bill of sale, clerk's record 864, the general warranty deed, clerk's record 866, the $3.1 million check that the appellant and his wife cashed when they gave up 80% of the Bordeaux property, clerk's record 4087. This was a legit and commercial real estate transaction. And just because the appellant has come back years later and said, everybody knew that it was an advance on my inheritance is not enough clear and specific. It is not sufficient to establish the lack of probable cause.
Okay.
All right, thank you. And Mr. Cooper, trying to even out the time here, we will give you one more extra minute.
Thank you, Your Honor. Justice Counsel, I wanted to address your question quickly. I do have 3 cases. In re Herbert from Dallas Court of Appeals in 2019. We hold that the trial court lacks discretion regarding the timely hearing when the movement acts. He only has the discretion when the movement acts with reasonable diligence to obtain such a hearing. In Windsor v. Fleming from Waco in 2019, the movement's failure to set the case for a timely hearing results in the movement forfeiting the TCPA's protections. And then Brown versus Gordon from the Dallas Court of Appeals again, if the defendant fails in its responsibility to obtain a timely hearing, then the case can proceed to trial on the claims without the delay of an interlocutory appeal. I think all 3 of them.
Sorry, didn't the trial court rescheduled their hearing? Right?
Correct.
The trial court moved the hearing on a sort of, on its own, presumably for its own docket related issues. I guess I'm just not clear.
I think our reply covers that pretty well, Your Honor, that when it was moved because one of the groups of appellees had not scheduled their hearing yet. And when they tried to schedule it, they couldn't get it on the same date. And so then they, had it rescheduled for a different date. The court picked that date, but when they picked it outside of 60 days, they had a responsibility to let the court know that that's outside of the TCPA deadlines. We need it moved in within the TCPA deadlines, or else we forfeit this right.
Is it jurisdiction, or the deadline's jurisdictional, like a motion for new trial, or?
No, it's not jurisdictional, but it is a precondition to receiving the benefits of the TCPA. It's a mandatory statutory provision, and they didn't meet that. Real quick, I want to address some of the things you just said. Opposing counsel mentioned that we had conceded that a lot of objections were proper. We conceded that those types of objections might be proper, but we did not concede that they were proper as to all the evidence in this case. And as far as pointing to the record for specific things, I think just our, again, the appellant's main brief has plenty of citations to the amended petition and the declaration to support all the elements of a prima facie case. And that, along with the court cases that were filed along with the second amended petition, which also detail what the other courts have found as far as the undue influence, the timing of bribes, and other information along those lines. So we think that there's plenty of evidence out there for a prima facie case. On malicious prosecution.
On evidence of bribes, are you talking about political contributions, or is there other things in the record?
We're talking about political contributions and contributions also to another a fund. It was set up for, I think, a charity that was related to the district attorney's office. I'm not exactly sure what the details of that one were, but yes, that could be also under the gambit of protected activity, except for the fact that it was coming as part of a bribery.
I mean, because there was not anything that went awry with the rules regarding political contributions. I mean, as far as how you make them and what the Ethics Commission provides for how you go about making and reporting these things, you're just delving into someone's reasoning of maybe why they were making that contribution, correct?
Correct, Your Honor.
Okay.
It sounds like protected political speech, though.
It would be, except for the fact that the allegations are that it was made for an improper manner and that other courts have found that the manner was improper. And that we have testimony in the case as far as the timing of that and when that money was coming in, and that once this indictments came down, there was no further money flowing from the co-conspirators into the DA's coffers.
What argument do you have specifically on the absence of probable cause element, especially in light of the question that Justice Hightower asked?
Again, I think the absence of probable cause is that we believe that all the parties involved understood the true nature of the Bordeaux property advance.
But how do we know? Like, you might believe that, but how does that get us where we need to be?
Well, at this point, that's our client's allegations, and it's in his declaration. And at this point, that declaration is based on statements of facts. Those aren't like legal conclusions. Those statements of facts are uncontroverted and can't be controverted at this initial stage of the TCPA. You're only supposed to consider the non-movance evidence, not the contrary evidence. Not that there is any contrary evidence. No one has said that this was a legitimate transaction. They've tried to raise that the Pickett decision multiple years later shows that it was a real transaction. That doesn't show what my client's understanding of the transaction was at the time. And he's very clearly pointed out the steps that were taken and why they believe that. And like I said, the documentary evidence supports that he had an exclusive 40-year provision to buy back the property, and it was triggered by the death of his father, which again shows that it was structured to be an advance on his inheritance. He gets this $3 million check. Once his father passes, then they get to buy back the property once he receives his inheritance. It does line up. The documents line up with what my client says. And then again, as far as citations of specific record, again, in our appellant's brief, we do cite to everything in the declaration that supports it, everything in the second amendment petition that supports it, the cases that are attached to his amendment petition. I think those things would be enough, but we also have the documentary evidence as far as the sale of the property and how it was structured. We have testimony in the record. And again, I'd be more than willing to put together something that points out a few additional pieces of prima facie evidence if you think that would be helpful.
The court will accept post-submission briefing. So as a matter of course, we do. Limited, please.
Yes, very much.
And the other side may, of course, respond if they want to. Any further questions from the panel? The case of Hill versus Kelleher, cause number 0120000419 CV is submitted. And the First Court of Appeals is hereby adjourned. Thank you for your argument, Counselor.
Thank you, Your Honors.
Thank you, Your Honor.